Are you guys able to see me okay?
Yes.
And hear me?
Yes.
Is my volume too loud?
Nope.
Yeah.
Good.
Hey,
Perfect.
Okay. This is for 10, no, it's 11 to 17. Okay, so it's 6 o'clock, and so we're going to get started. I believe that I am recording. Let me just make sure, because last time it did not record. So I want to make sure that I am recording everything. It looks like it is.
hey, excuse me.
Okay. Yeah. So, good afternoon or evening, depending on, I guess it's evening for all of us now since it's 6 o'clock. Right? I see, let's see. Kenneth, that was,
That's me. Can you hear me?
yes, I can hear you and see you.
Okay.
Hello.
Hello.
This is Selena's son, and my mother has been sick for the past week, so she hasn't been able to get her work in. She'll get it last week and this week work in soon.
Selena? You're Selena's son, and so you're saying she'll get her work in for next week?
So last week and this week.
Okay. Can you have her email me?
Yes.
Okay.
All right. Thank you.
You're welcome. Okay. So, so welcome to our second live session. I just wanted to know if you guys had any general questions about anything. One thing I have done is I tried to give all of you access to the discussion question County of Trinity. Were you all able to get access?
Yes.
Yes. Okay, because I added everyone to the list, and then I still started getting emails, even though I went through and added everyone to give them access. So I don't know what's going on with that. What I am going to do is try to discuss with the technical folks to make sure you have access to everything, because that shouldn't have happened. Like the other discussion boards for 1 and 2, you guys had access without asking me. So
Right.
I'm just wondering why that particular one, you weren't able to get access to it automatically, that I had to get the access.
Right.
I have a question, and if it's
What's your name?
BB, Deborah Severe BB. Hi everyone. And if this is like too involved to be a short question or not something you want to get into right now, then just tell me. And I will embarrass myself with this question, but maybe I'm not the only one.
Okay.
I have read, and I feel like I understand when we talk about statute of frauds, like all the criteria, all the elements and all of that. But one thing that continues to sort of is not connecting is when I read in the book, and it seems like it's sort of, I don't know how to put it. It's like it's reverse of, like it'll say, does this meet the statute of frauds? And where I think it's going to say yes, it says it's like the opposite. So I'm thinking, am I not understanding the terminology of statute of fraud? Am I even explaining this right? Does anybody else have the same problem? There's actually a page in our book where it says, does this meet this? And it's like, absolutely, it's like all the criteria, but then the answer is like the reverse. So are we saying that am I not understanding it right? I feel like it's the opposite.
Right.
I don't know.
Why don't we go through the materials today? I'll go through the PowerPoints.
Okay.
And let's see if that clarifies anything.
Answers that question.
Yeah, because the statute of frauds is one of those concepts in contracts that's kind of hard to grasp initially. And so maybe you have to look at it a different way, from a different perspective. But it isn't easy for law students either to grasp.
Well, it's like I feel like I know that the example that they're giving, I know if it's one that meets it or not. But then I
Right.
feel like the answer of it being yes or no is exactly the opposite of what. So I don't know if I'm just not understanding the actual term statute of frauds. Like,
Right.
that's what I'm. So.
Okay.
Yeah, let's go forward. I'm sorry, like I said, I might just embarrass myself, but
No, absolutely not.
I have read it back and forth, and I thought I had a pretty good grasp of contracts in general, and I'm starting to feel just blonder by the minute. So,
But that's what we're here for, and that's kind of what the live session is for, so that we can address some of those concerns. How about the rest of you? How are you feeling about the statute?
I would have to agree with her.
That's confusing.
I would agree because I was confused by the discussion question. I mean, I felt about it one way initially, but then when I reread some of the material or in the book, I thought, wait a minute, you know, what am I not getting here? So in my question, I answered it about 3 different ways, and I kind of went, I'm sorry, but I just was confused. You know, I'm not sure I get it.
Right. Okay.
This is Dorothy. I kind of, thank you, Deborah, for opening up the door. I think there were some aspects, I guess I felt like I got most of it, but there were just some gaps in my understanding. And I sent you, especially when I took the quiz, and I sent you an email asking to clarify. So I don't want to ask those questions because it is the quiz and it's not due yet. So
I answered your questions. I directed you to the page. Did that help you?
I just checked my email and I didn't get a response.
Which email did you send it to?
I sent it from Moodle.
Okay. It was so your course email.
Yeah, I had 2 questions
Right.
from my quiz.
I thought that I responded. And so let's go through and see. I think if you look at it in terms of, okay, you have offer, acceptance, consideration, there's a contract, right? Okay, so when you're looking at the statute of frauds, can that contract be enforced? Can you enforce it? And that's what the statute of frauds is all about. Can you enforce the contract? And so it depends on, the statute of frauds depends on the types of agreements. When it says it comes under the statute of frauds, that means that it's an agreement that requires a writing. That's all it means. You can have an oral contract on anything, right? But the statute of frauds, there are certain types of contracts where you need more than just an oral agreement. It has to be in a writing. And so if you look at the statute of frauds as a writing requirement for these types of contracts, if it's an oral contract, then you wouldn't be able to enforce it if it falls under those 5 categories of contracts. And so if you look at it in terms of that, there is a contract that might have been made, whether it's oral or in writing. The question is that writing required because of the type of contract that it is? Does that help with how you view the statute of frauds?
Yes.
And then okay, so your number just came up. It's just you on the phone. I don't want to say your phone number, but it ends in 77.
Yeah.
I don't have your
It's
name.
Rudy Gonzalez. Oh, Rudy Gonzalez. I'm calling in via my iPhone.
Oh, okay. All right, Rudy. I just
So,
want to
yeah.
make sure that I give you credit for today.
Yeah, Rudy
Without
Gonzalez.
taking
Yeah.
roll, because I understand that teachers don't normally do that online. But I can see you, but I just see a phone number, so I wasn't
Okay,
able
yeah,
to
that's me.
give you credit for today.
Rudy Gonzalez, correct.
All right, so I have you. Okay, so let's go through, I'm gonna share my screen with you. Let's go through the PowerPoint and then I'll stop for a question, but I hope that I'll give you an opportunity within the, within my lecture to have questions about the County of Trinity. Just so you know, that is an actual case that you know, our office deals with or is dealing with. And so, you know, it's not the parties, but the examples and the materials that I have given you in this course, they're based on real situations. And so it comes up, you know, like you saw in the first week, contracts are everywhere. We make contracts all the time. We just don't identify, oh, I just made a contract. And so there's always issues that come up with those contracts when, you know, you want to get out of it, or you don't do something you're supposed to do, or the other person doesn't do what they are supposed to do. And so, so hopefully we can answer some of those questions. Don't feel bad about it seeming a little vague at this time, because it is a vague concept, not easy to understand. And so hopefully I can shed some light on that today. So what I want to do is I'm going to share my screen with you. And okay, so are you guys able to see my PowerPoint for the Fraud Unit 3?
Yes.
Okay. So let's move forward. So the questions we're going to try to answer during this session is, what is a statute of frauds and which agreements are covered by the statute of frauds? What are the defenses to enforcement of a contract based on the agreement process? And then what are the defenses to enforcement of a contract based on what it says, what the agreement says? Okay, so what is the statute of frauds? Okay. It is a defense to enforcement of a contract. So you have a contract, you've had the offer acceptance, and the consideration is there, but can you enforce it? And that's what we're dealing with. So it requires that certain agreements must be in writing, or it must be evidenced by writing to be enforceable. So that's the basic, you know, reason for it. Use it as a defense to enforcement of a contract. And so what is the purpose? Its purpose is to prevent false claims by an unethical plaintiff. In the case of an oral agreement, it's your word against their word, right? He said, she said, who's right, right? And so certain agreements are so important that you have to have a writing. And that's basically what the statute of frauds is. It's saying in those agreements, when it says fall under the statute of frauds, that just means that those agreements must be in writing. And so it's based on the Old English statute, where unethical plaintiffs or parties would bring someone to court and basically lie. And so how do you get around someone lying? Who's telling the truth, right? And so it kind of addressed that. So that's where we get that whole concept of the statute of frauds. It's basically to protect the parties to an agreement. And so each state has its own statute of frauds law, meaning that some states may require prenuptial agreements to be in writing. Other states may not. But there are some general contracts that most states, if not all, require a writing. And so you would have to look at each individual state statute of frauds, but we're just looking at the broad concept of it. And so with the County of Trinity, so if you're thinking about the purpose of the statute, right? So with the County of Trinity, fact pattern fall under the purpose stated in the Old English statute of fraud laws? And I'm asking you guys that. What do you think? Based on your reading?
I believe so.
Go ahead, Lorenzo.
Yes.
I think it's fraud
Mm-hmm.
because the way he went about trying to, I guess he forged his signature.
Mm-hmm.
And have a living relative. How did he find a living relative when the county or wherever they're located couldn't find a church couldn't find the individual? And he just property for himself. So, like you said, and he could have went about paying on the taxes, which would have gave him the property.
Mm-hmm.
That's fraud, in my opinion.
Right. But is it a contract that would fall under the purpose of the statute of frauds? Remember, the purpose was to prevent unethical parties coming into court and lying, basically, right?
Well,
Yes, it would.
Yes,
Yes, it would.
Mm-hmm.
it should, because this is a transfer of interest in real estate. So it's dealing with real estate transfer, so it should be in writing.
Right. So why? And that's one of the reasons why, is because it involves real estate.
Mm-hmm.
And anytime you are transferring real estate, you need to have a writing. And so the facts given to you in County of Trinity, where there was a quitclaim deed, would that qualify as a writing to transfer that property?
yes.
Why do you say that?
It's
I
a
would say no.
document, it's a writing,
It's a legal document.
it had signatures. Well, even if it was maybe fraudulent, but it was a writing that he turned in as a a valid document. He presented it to the county or whatever.
But when
He can get ownership.
the person who's still in the document, you need to see the person's signature right there at that moment, like a lawyer or a notary public or a notary. So that's what I'm
That's
thinking.
what I would think. Yeah, Professor, this is Rudy. I would think that a quitclaim deed signature wouldn't be sufficient when we're talking about real estate. And the reason why I believe that is because I think it's customary when you're selling real estate that there are there's more than just one contract. You know, there are several agreements. In addition to that, there's typically an escrow period, and that would, in my opinion, raise a red flag. And I would think there would be more opportunities for other signatures in the sale of real estate.
Absolutely. And that's the issue there, because if you look at the other materials that I gave you concerning a quitclaim deed, it basically gives what the other party has. So if they have no interest and they transfer something to you, they're transferring nothing, because there's no type of validity in, basically, it's not verifying that they actually had the right to do that in a quitclaim deed. A quitclaim deed can only transfer what a person actually has. It's not sufficient to say you actually have this. And so anyone can do a quitclaim deed. What would you think about the public policy if anyone could just sign a quitclaim deed, because anybody can record anything, and then they can take your property, right?
See, but I was under the impression that the quitclaim deed it had to be filed in the government's office, you know, with a notary and all this stuff. Or with the notary. And the person had to sign in front of the notary. I mean, so that, because at first I thought, I mean, it's fraud regardless. But but at first I thought the same thing that Lorenzo was saying. He forged a signature. But if the person is required to sign in front of the notary, it has to be more than one person involved over here.
You know what? I have to disagree because not necessarily. If he forged the signature and then this is Connie.
Okay.
If he forged the signature and then took it to the notary person with his ID and stuff, then you would have no way of saying that this person signed.
Yeah, but the notary is not supposed
Oh,
to
the
notarize that.
notary.
The notary is there for.
I can't hear everybody.
I'm a notary. You can't sign something. You can't notarize something if it's already pre-signed.
Already been signed.
Okay.
That's right.
But
Okay.
but there's ways also. This is you know, it could have been someone that he knew personally that knows.
Right.
Yeah, exactly. I mean, somebody else involved.
Yeah.
So listen, let me jump in just to steer the conversation. So if you look at the facts, you have Mr. Jones that comes in, and all of a sudden they can find somebody from the board when no one else could find anyone from the church. And so you can present someone to a notary if they have an ID. A notary is not going to say, oh, you have the right to do this. The notary is just going to notarize your signature, and if you have a valid identification, and you are paying them for the notary services, then, you know, you can present
But
anyone
that is true.
with a valid ID. And they can be
even though he found a member of the board, depending on what the bylaws were for that church, that one single member may not be able to in himself sign over property.
Absolutely. So let's move forward unless anyone else has any questions or comments about the County of Trinity.
I have one. Yeah, I have one question. When I wrote my comments, they were pretty much everything that's already been said here. That was my mindset too. But I was thinking about it last night, and I thought, you know, when we're told the story this way and it's isolated, we get so caught up on the fact that, oh, he must be forging it and, you know, and all of that. But in the big scheme of things, in a real community, how much time investment is a county really, you know, supposed to spend making sure that what was presented to them, I think it was Dorothy that said, somebody said, you know, that's how he presented it. Like, I feel like we're like the watchers of a movie. Like, maybe we can see all the reasons that it's fraudulent, but in theory, if they get presented a document, what is the onus on the county to like try to keep everybody honest? I mean,
as long as that's where the notary comes in.
Yeah.
If you're presenting that valid identification to a notary, then and it's notarized and they have their notary seal. The county, just think about that. If the county had to investigate
that's what I started thinking.
Every notary.
They can't police everybody.
There's no way they can do that. That is why when you're dealing with a quit claim deed, if you have no interest in the property, then you cannot give an interest in the property.
That's right.
Deed is just a deed. Okay, it doesn't say that you actually have that interest, and so that there's a lot of problems with there's some issues with that because if that's the only right presented and we're dealing with the sale of real estate, that would probably violate the statute of frauds. And let's see why. Let's move on, and then we can take some other questions. And then post in your discussion post for County of Trinity, and I can comment also on some of those, or you can send me a question if you have a question about it. But let's move on. So what agreements fall under the statute of frauds, meaning what agreements must be in writing?
Sale of real estate.
Okay.
So if it's a transfer of interest in real estate, you need an agreement that concerns that real estate. The deed, when you record a deed, it is just, it is evidence that an agreement was made concerning the property. It is not an agreement. It is just evidence of the agreement, and then you record the deed of trust as a result of you having entered into an agreement concerning that real estate. So real estate must be in writing if you're going to transfer title or interest. Service contracts not capable of being performed within 1 year of the date of the contract. So if it's a 2-year contract, 2-year employment contract, that 2-year employment contract must be in writing. And then if it's for the sale of goods, remember the Uniform Commercial Code, UCC, it covers goods, it covers the sale of goods. If it's something for $500 or more in value, then it must be in writing. So when you purchase that car, you have to have a writing, right? And so it would require it to have a writing for that. They tried to up that to $5,000 because that $500 is an old figure. So it's basically something of value when you're looking at the sale of goods. Prenuptial and antenuptial agreements must be in writing, and then surety guarantees. If you're answering the debt of another, if you say, I'm going to pay this car, if they don't pay it, if you're co-signing on a car, you need to sign. You need to have a writing saying, I'm going to be the one to pay if they don't pay. So those are the types of agreement. When it says fall under the statute of frauds, means that a writing is required for those types of agreement. You can't just have an oral agreement if it involves any of those 5 broad categories.
Professor Trinnell?
Yes?
Why are the last 2, the prenup, the antenup, and the surety, why are those not listed in the book?
Because those are not as common as far as the states are concerned. Remember, the statute of frauds is based on each state. And so the first 3 that are in the book are the ones that are most common across the states. Not all states would require prenuptial or sureties. And so those are the main ones. The 3 that are in the book are the main ones. These are just other types of agreements that may fall under the statute of frauds and require a writing. Okay. So what is the effect of the oral contract? An oral contract concerning these enumerated types of contracts will not be enforceable in a court of law. So you can't go to court and say, hey, they told me I could have this plot of land and there's no written agreement. There's just an oral contract. You could not enforce that oral contract in writing. I mean, in court.
Professor?
Yes.
This is Brenda. So if you have if somebody told you that orally and you had a witness, you still couldn't enforce it in the court of law?
No.
Get out.
No, because if it's an agreement that requires a writing,
right?
The fact that somebody witnessed it is not sufficient, unless there's an exception. If there's some type of performance, and that falls under one of the exceptions to the statute of frauds, is if there's some type of performance, then the court may enforce it, but it's based on an equity principle. So it's based on just a different principle. Does that make sense? Yeah.
Yes.
Okay. So why the statute of fraud? Its written form is more certain and concrete than form, right? You can rely on what it says on a paper. Anyone can say anything, right? They can say, oh, I didn't say that. That's not what I agreed to. But if it's in writing, then, it helps as far as your ability to enforce that agreement in court. So certain types of contracts require that there be proof in writing in order to be enforced through the court. So that's basically what it's saying. Can you enforce it? So if it's in one of those 5 categories, or 3, let's just talk about the 3 in the book. If it's one of those 3 categories, you need to have that proof in writing in order to go to court and say, hey, I've been wronged, or hey, to uphold someone's agreement or promise that they made under that agreement. So if the contract falls within the statute of fraud, then there are certain writing requirements that you must satisfy under the statute of fraud. So not only do you have to look at the categories where writing is required, what must that writing contain? Okay, and so basically, the terms that must be in writing, it depends on the statute of the state again. The statute of frauds is, specific to each jurisdiction and their requirements. These are just general principles related to statute of frauds. So under the UCC, that's for the sale of goods, remember. You must have the quantity of the term it must be in writing. Okay, how much are you buying, right? That has to be in the writing to go in court and enforce. And then who must sign the writing? Did I miss this? Okay, going back. Okay, it's advancing me forward, not going back. Hold on. Let's go back. All right. Let's go here. It's going to start me all over. Okay. I'll just forward. Okay. Okay. So that's where we were. So under the UCC, that's the quantity. And then who must sign the agreement? It's important that if the defendant or the party against whom you are seeking enforcement, they must have signed it, the writing. So if you want to say, hey, this contract, I want to enforce this contract, I want this party to pay based on what they said in this contract, you can't be the only one who has signed that contract. You need the defendant or the other party's signature would have to be on that writing in order to go to court and say, enforce your rights, basically, against that party. So that's who must sign it.
Can I ask,
yes,
when we're using the word defendant here, is that kind of the same as the grantor? And like if we were to use the word grantor and grantee?
Grantor, grantee, maybe, maybe not. It really just depends on what they're seeking to enforce.
I'm just confused when we say the defendant. Like who's the giver?
The defendant is typically the party you are going after to get something. It's
like the promise.
So this is only like when something's gone wrong with the contract?
Right. And you want to enforce something within that contract. And it's one of those 5 types of contract, or 3, let's say 3. One of those 3 types of contracts. Let's just use the real estate, okay? You want to go in and enforce it, then the person who you are going against must have signed that contract. So if you're going against the seller.
So it could be either side that decided that it went awry.
Right.
And then that would put the other side on the defense.
Right.
Okay, I didn't get that at first, but I do now. Thank you.
Yeah, so if whoever you're going against to seek to enforce the contract, that party that you're going against must have signed the contract. Okay, they must be the ones who are on there who have agreed to the contract. And then the exception is if it's merchants under the UCC, there is an exception. If the writing is signed by the plaintiff or the party that is going to get or seek justice, it's satisfied if the defendant has failed to object in writing within 10 days. So it gives merchants 10 days to say, hey, no, I didn't agree to that. Okay. If it's after the 10 days and the plaintiff is the only one who has signed it, you can still enforce your rights if it's a contract for the sale of goods. And it involves merchants, meaning businesses that are doing business with one another. So let's move on. So what is the exception? What if the agreement falls under the statute of frauds, but there is no writing? There are a couple of exceptions to the writing requirement. One of them is part performance. So if you start performing the contract, then that may be an exception to the writing requirement, because your performance is evidence of some type of agreement, right? If you start doing something based on what someone tells you, or there's an agreement, then your performance could substitute that writing requirement when you go in to enforce your rights. The other exception is reliance. Under Restatement Second, Section 139, if you rely on an oral promise to your detriment, for example, there was an example in the book, you moved to Hawaii for a new job, and then for some reason, you know, you're let go, and you've already gone to Hawaii. So you will be able to enforce that agreement. Basically, it's just saying you get to go to court to enforce your rights, even though you may not have a writing. Remember, we're dealing with, under the statute of frauds, agreements that must be in writing, and that's the big portion of the statute of frauds. So are there any questions about any of that? Or are you following along so far?
Does that reliance apply to, just say if I want to, just say I got hired by King County in Seattle, and I decided I was ready to move out there, and I was out there a week, and they get rid of the job. Does that apply to government jobs too, or only on the outside, civil jobs?
You know, the governments are always a little different because they only have their special set of rules. So it may or may not apply to a governmental entity. A lot of times they're shielded from liability that the private sector is shielded, that the private sector is liable for, because it's a governmental entity. So it really just depends. I can't say yes.
And with the part performance, are the courts likely to, if you do like perform part of it, maybe to only then say, well, then they hold you to that contractual part, but maybe not to the other parts of the contract that you claim that you didn't perform or understand? I mean, do they tend to dissect the performance? Like if you have a contract and you're saying part, like if you start to, maybe it's an agreement for like a lease or something, and then you say, oh, well, you know, I didn't understand it, but they say, oh, well, you started paying the rent, but you maybe didn't understand these other 5 things. Like, will they divide the contract up in parts and hold you like responsible for part of it, but not responsible for other parts because it wasn't in writing?
You know what? It really depends. Remember with contracts, what they try to do is when they try to make the party whole, or they try to make the party whole as if the contract had, you completed the contract, right? When there's part performance like that, the courts have discretion to fashion an equitable remedy. So it may be that whether or not you understood it or not, if you start paying rent and they start cashing your checks, then you probably agree to those other provisions as well, unless, as you see later on, it's unconscionable. There's something within that agreement that no one should have to agree to. And so really, it just depends on the circumstances. All of it's very fact specific. And so the courts will try to fashion a remedy based on if the contract had been fully performed. I hope that helps you. It's like without more facts.
It is. Thank you. Thank you.
Okay, so let's move on. I just want to make sure we're at the right time. So with the writing exception, the court's determination that a party's action taken in reliance on the oral agreement, it substitutes for the writing, and it takes the transaction out of the scope of the statute of frauds and thus can enforce. Basically, it's saying that the court will enforce it even though there's no writing because of those substitutes. because of the fraud performance and because of some type of reliance, some type of detrimental reliance. And then, Renzo, to answer your question, it has to, sometimes it has to be egregious, or it has to be a reasonable reliance, I should say. So if those terms like reasonable, it really is driven by the facts. And so, without more, if the court sees it as reasonable reliance, then the court is more likely to give you some type of relief, even if there is no writing. Questions? Okay, let's move on. All right, so let's just summarize the statute of frauds. So its contract law's desire for certainty has placed a writing requirement on certain types of contracts to ensure against fraud. These include transfer of real property interests, contracts that are not performable within 1 year, contracts in consideration of marriage, sureties and guarantees. That means you're answering the debts of another, contracts under the Uniform Commercial Code for the sale of goods that are valued at over $500 or that are over $500, the terms of a contract. And so those types of agreements will require a writing. You just can't have an oral contract in order to go to court to enforce your rights. And then even if the statute of fraud does apply and the writing requirement is not met, the court may still give the aggrieved party who was not at fault a remedy to prevent injustice if that party has partially performed on the agreement. Okay, so what are some of the other defenses to enforcement of the contract? So there are two other types of defenses that we go over in your reading materials. The first one is if there's defenses based on flaws in the agreement process. And then the other is defenses based on what the agreement says. Okay? So when we're discussing defenses, we're talking about agreements that are not legally enforceable, not necessarily a breach of contract, where there is actual agreement and the parties are performing and then they stop. We're not talking about that. We're talking about defenses to the agreement saying that it is not a legally enforceable agreement. Okay, so defenses based on the agreement process. How did you reach that agreement? Right? There's a defense. There's several defenses. And the first one is duress. If someone forces you to agree to something, and then, that agreement shouldn't be enforceable, right? It's not legally enforceable if they made you. If someone puts a gun to your back and says, you agreed to give me this house, or I'm going to shoot you. I mean, that's ridiculous, but I'm just making the point. That would be duress. So you sign under duress. So if you misrepresent the facts, then that agreement cannot be legally enforceable. One thing I'm thinking about is like when you're buying a used car and they turn back the miles, that's a misrepresentation, right? Of the facts. That car has more miles on it than you agreed to, okay? And then non-disclosure and concealment. So when you're dealing with non-disclosure and you need concealment. Some things you don't have to disclose, especially if it's something obvious. But if you conceal it and you don't disclose it, there's an example in the book about if there's a hole in the ground or in the car, in the bottom of the car, and you cover it up, right? If the hole is there and you don't have the mats to cover it up, then and the person agrees, then that's not a defense. But if you cover it up and you don't disclose it, then that might be a defense on the process. And then mistakes of facts. If you have a mistake about the facts, then there might not be a legally enforceable agreement. Remember, in the beginning, first chapter, contracts involve, you have to have mutual
Where are you?
consent, right? And so if there's a mistake, if you guys both have a mistake as to a material fact,
Darling, just please
then
don't.
that agreement is voidable. I can hear whoever is talking in the background. I can hear your background. I don't think you're muted. And then if there's a mistake by one party, okay, there's a unilateral mistake. It applies when there's a clerical or mathematical mistake that makes the agreement unconscionable, right? Say you are purchasing a used car for $2,000, then it says $200,000, but the car is only worth, $2,500, right? And there's a mistake, some type of clerical mistake. Then you can't enforce that agreement saying, oh, you owe me $200,000. That's what the agreement says, right? No court is going to enforce that agreement.
Where's the fine line though with that? Like, I know they say like when somebody like a retailer advertises something, the fine line between where they say, okay, like you just said, if it's a car and it's a $25,000 car and the ad comes out that says it's $2.50. I mean, that's a big mistake, but where's the fine line with if Best Buy says we're offering this TV for $500 and they're like, oh, that was such a big mistake that they have to actually stand by it? I mean, who determines that what's outrageous, what's not?
There are advertising laws, and that's a little bit different. That would be under the UCC with the sale of goods, but there are probably certain provisions that go to that, and some of it is like it's clerical mistake, right? If Best Buy, if it's a $5,000 TV, the new TVs that are curved, and it's a 80-inch TV, and it says $500, and it's brand new, right? That was probably a clerical error, and you probably can't enforce that, right? It depends on how egregious that is, how big it is. It has to be something material, but as far as businesses and retail, there are certain provisions that apply to that as well. And they would look at that and say, no, you know that TV is not $500. That's definitely a mistake. I doubt that you would be able to get out of the store with it or enforce that. So it really just depends. Okay, any questions about defenses based on, I'm going to have to start over again because it went forward. Let me go back. Any questions about defenses based on what the agreement says? I mean, the agreement process. Nope. Okay, let's move forward. Okay, my slide ends are taking forever. So there's defenses based on the agreement process. Okay? You force someone to agree to a contract. You can't enforce that contract. And then there are defenses based on what the agreement says. What are the terms of the agreement? You have legal contracts and contracts against public policy. Typically, with the legal contracts, you're dealing with a subject matter that violates the law, whether it's criminal or civil laws, right? A legal contract would be charging 100% interest on something that in your state says you can't charge interest above 30% interest. Then that would be an illegal contract. And then public policy, and some of it is kind of overlapping. One is a covenant not to compete. That is a contract that or an agreement that courts typically won't enforce. Because when you leave your employer, the former employer cannot limit your ability to make a living. There's no restraint on trade, right? We live in a free market society where you can go out and hang your shingle and sell your widget, and so we're allowed to do that. And so covenants not to compete are typically not enforceable. And that's just broadly speaking. Typically what happens is you might get the employer, the former employee, they may have taken a trade secret. So you can get them from that. They can compete, but they can't get stuff from you in order to start their job. So, you might not be able to uphold that covenant not to compete, but you may be able to uphold them taking information, materials that belong to that former employee or employer, I should say. And so basically these agreements are against public policy, and they can also be illegal. For example, if you contract to sell your baby on the black market for adoptions, okay, there's a public policy against it, right? We don't want people selling their babies. And so that is not only an illegal contract, but it's also against public policy. Typically, when you're dealing with public policy, you're dealing with agreements that shock the conscience. It's like there's no way you can uphold an agreement like that, right? So you can't go to court and enforce that agreement. And so then you have unconscionable agreements. And some of this kind of overlaps. It may be unconscionable, it may be against public policy, and it may be illegal. It may satisfy all of those. So unconscionable agreements are a defense to enforcing that agreement in court. That's what we're dealing with. Can apply to individual terms within an agreement or the entire agreement. So if it's individual terms, agreeing to litigate disputes in an unrelated foreign country. So say you have a valid agreement between two businesses, two parties, and there's just this one crazy term that says, if you have a dispute, we have to go to Dubai to assert our legal rights, right? That term the court can strike out that term because that's an individual term, but the rest of the agreement would be fine. Compared to the entire agreement, my battery's running low. The entire agreement may be something that now where the employer says that you have to sign an arbitration agreement to litigate your disputes if you're an employee against the company, but if you don't sign it, then you won't get your pay raises or any benefits, right? That's an unconscionable agreement. You can't enforce employees to an arbitration agreement in exchange for being paid, right? That shocks the conscience. Any questions? You guys are quiet. And so,
what if it's a term for employment?
What about it?
What if it's in an employment contract that states that if you don't sign saying that arbitration agreement to litigate all disputes, you will not be hired?
Right. That is unconscionable. It's not, employers do it all the time. There's a case with Circuit City where in order to be hired, you had to agree to arbitration. And so the court found that agreement was unconscionable. And so it didn't enforce that arbitration agreement. So if you did have a dispute with Circuit City, then you can go to court and sue them in a court of law and not have to go to arbitration. And so, yes, employer, they do it. Whether or not it can be enforced, that's the whole thing. Employers will put anything in those agreements. And a lot of times we want a job, so we sign them and we don't think about that. And so, but when the time comes, then your attorney, if it falls under the category of an unconscionable agreement based on its term or how the process works, that would be also evidence of procedural defense to the process of the agreement, right? You couldn't get a job unless you signed it, right? So you had to sign. That's the agreement process. So that would be both procedurally, substantively unconscionable.
This is ask on that. Like I work on the rail. Every 5 years we have a contract up for arbitration.
Right.
I'm specifically looking at healthcare.
Mm-hmm.
And so we were presented a healthcare plan with our last contract where the president of the union came in, held this big meeting here in Indianapolis, and he said, well, this side letter to the agreement is what we would suggest you go with because it's better than what you had before.
Right.
We had not ratified the contract. We had not even voted the contract, and letter had already been signed.
Right.
Could we, as members in the craft, go to court on that?
Probably. Do you have are you unionized? Do you have a union rep?
Right. Yeah, we're unionized. But I mean, could we go? I guess the question is, it seems as if the company and those up top in the union went ahead and signed a letter and ratified a contract without us voting on the contract.
Right. Absolutely. I would challenge that, and I would take that to my union.
Yeah. Well, the union was coming to us saying, we've already done this, and so this is the way it be.
Right.
And we had not ratified the contract yet.
Right. Yeah, I think there's some. I think that there. Go ahead, Yvonne.
I wanted to sort of say I believe that there would be a duty of fair representation charge that you would be able to file with the labor board against the association, your union. Also, you would want to take a look at your bylaws, because if the bylaws that govern how you ratify anything that would be bargained, they would have to follow them.
Okay.
Yeah, so that's something that you would have to look at the agreement that you have, if they have the right to do that. If you've granted them, your union representative, the right to ratify those type of agreements on your behalf without discussing it with them. And sometimes unequal bargaining power between an employee and employer is enough to make that agreement unenforceable. But you would have to, with, like Yvonne said, you have to look at that, speak with the union or a labor attorney, and look at those agreements and see if, actually they have the right to do that. But yes, typically they are, but usually you find out that it's not enforceable when you go to court to assert those rights.
Yeah. Okay, thank you.
You're welcome. So let's wrap up. You have any questions other than what we've discussed already? Any questions?
I have a one. Who gets to determine the unconscionable or egregious? Are contracts usually done by a bench trial or jury trial?
It depends on where you are and what court, and if you post the jury fees, it really just depends. Most of the time it's the jury, but some states there is a bench trial. So it all just depends on your state, local laws, right? It could be either the jury or the judge.
I just think sometimes when you, like those intangible things like who gets to decide what is unreasonable, what's egregious, what is reasonable person, and what was that thing in the book? It said leaving it as they found it.
Mm-hmm.
I'm not sure I understood exactly what that meant.
I'm not sure what context you're speaking of.
There was something in the book that said that the goal is to something about leave it as we found it, or get it.
When they committed illegal acts, both parties committed illegal acts.
Oh, I know what you're talking about.
Judge won't rule on it, basically, or
Yeah.
they
Right.
decide that.
Thank you for
I think reference to the contract that is based on an illegal subject matter, and so the court is not going to enforce it rights for anybody if the subject matter of the contract is illegal. There's no enforcement, so the court's going to leave it as it. The court is not going to give any relief to either party because the agreement was illegal. So that's basically what that was saying.
Oh, I totally have that wrong then. Okay, thank you.
Yeah. So anyway, it is now 7 o'clock. If you have any further questions, always feel free to email me. I tried to give everyone access to the discussion board 3. And so I'm still getting emails. I'll check with Trinity about that with the technical team, and I'll just make sure that that everything that is supposed to happen with respect to our discussion boards, our media posting, everything that you shouldn't have to do that. And that's my understanding that Trinity was supposed to take care of that, their online platform. And so just email me if you have any questions.
Okay.
Or problems with anything, and I'll do my best to address it.
Okay.
Professor, this is
Yes.
Brenda. I have a weird situation. This case, the Trinity case,
yes,
we had that same type of case going on with our church. We was trying to buy a church, and all the board members supposed to have been passed on. And we had them look for it, and we found one board member, and he was a junior board member and was not on, anyway, he was the only one that's still living. And he and the wife of the pastor that passed away, she wanted to sell the church, and she wanted to sell it to us. Well, that one board member refused to let her sell that church.
Okay. So that's like real life, and ours was not a church. It was not a church, so it was some other type of organization. So I just tried to make it as different from our real facts as possible.
Right.
See, contract law affects it all.
Right.
Dealing with that very issue right now. So I mean, if that board member has the authority to block the sale, then you might have to just, go to another site or try to assert your rights legally and see if the court will agree. Because what benefit is it to him?
To him, that's right. That's right. He's
Well,
not
what
using
is the benefit? So, but yeah, that is the law, and that is why we have attorneys, and that's why we have statutes that hopefully try to protect the parties in situations like that. And I just say, try to find a good attorney.
Okay, thank you.
You're welcome. You guys have a great evening. And I will see you in 2 weeks, and you can email me anytime.
Okay.
you.
Bye, everyone.
Thank you.
Bye.
Thank you.
Bye, everybody.
Bye, everyone.
Bye.
Bye.
Bye, Brenda.